Well, ladies and gentlemen, I am Ugo Bernalicis, a member of the French National Assembly and a member of La France Insoumise, a left-wing political group. I am very honored to attend your conference as a speaker, and I thank you for inviting me. As particular, I would like to thank Cyril Nelson for our invitation and the exchanges we had during a stay in Paris. I apologize in advance for my English, so I took the liberty to prepare some written notes of what I want to share with you. The concept of whistleblowing is not new, but in a particular liberal society where every field is in competition and use just-in-time production, systemic dysfunctions multiplied at the heart of our democracy. The regulatory bodies, the supervisory bodies, the social dialogue bodies, trade unions or not, suffer substantial cost reductions and precariousness of their status. Therefore, the management of these functions lies on the individuals themselves. There is no more intermediary. Through this past 5 years mandate, major crises have highlighted the need to strengthen the framework for revealing malfunctions in France. The explosion and fire at the Lubrizol chemical plant in Rouen, cases of mistreatment and racism in the prisons of the courthouse of Paris, cases of barbarism at the industrial slaughterhouse of Saubeval Calves in Dordogne, cases of child mistreatment in child welfare services, or managing the COVID-19 crisis in hospitals, etc. I have received many testimonies from whistleblowers who particularly affected me. The stories of their administrative and judicial processes, but also human, are beyond comprehension. While it is to be congratulated that this concept of whistleblowing goes hand in hand with the requirement for more active citizenship in our society, the fact remains that these people are crushed by the warning they reveal. That is why it is essential to reinvent the role and place of the intermediary bodies, of these control bodies that are supposed to prevent and treat any dysfunction in an institution or in private and public companies. In a word, I did not come out unscathed from my meetings with all these whistleblowers, and I want to propose effective solutions to put an end to their ordeal. That's why I have launched a legislative work to give visibility to this issue and to propose a text aimed at making the protection that society owes to these people effective. I have proposed 2 bills. At the same time, the European Union adopted a directive on 23 October 2019 aimed at harmonizing the protection of whistleblowers in Europe, drawing heavily on the French schemes of the law called Sapin II on 2016. I will not go back over certain political points, in particular the fact that the French government in this sequence opposed several points of the directive, such as the establishment of autonomous warning systems. It was my colleague Sylvain Wasserman from the majority group who was in charge of defending the bill aimed at the transposition of this European directive by repeating some of my proposals. The French law modifies the protection of whistleblowers' general device. Indeed, the new law clarifies the definition of the whistleblower, the field of information considered as an alert, and complete the list of applicable secrets. Henceforth, a natural person is recognized as a whistleblower who reports or discloses without direct financial compensation and acting in good faith information relating to a crime, an offense, a threat, or a prejudice to the general interest, or a violation or an attempt to conceal a violation of international or European Union law, the law, or a regulation. The conditions of disinterest is removed and replaced by a lack of financial consideration, making the admissibility of the alert more flexible. Some protections are finally recognized for people around whistleblowers. Finally, the reporting channels available to the whistleblower to report facts if they want to benefit from protection are simplified. In particular, any hierarchy between them is removed. However, is this new legislative framework enough? Certainly not. There is indeed the need to monitor the enforcement of the Act, which is what will be learned this year. But for my part, the legislative framework remains very theoretical, and I will highlight my concrete proposals. They are of two kinds. The first deals with the desire to flesh out the law in order to better respond to the reality of the whistleblowers' processes. Financial assistance must be provided to whistleblowers. This remains essential, and the legislative framework does not allow it yet. This is an essential condition for me, because it makes it possible to preserve the recognition of their status by society, but also to allow them to directly supplement the consequences of placarding decisions, gag procedures, etc. It is also necessary to strengthen the range of individualized solutions to be provided to whistleblowers, providing access to legal aid regardless of income, fully subscribing to the personal training account, offering psychological support, creating an easier path to employment, etc. The second is about the priority of effective rights by giving the necessary means to the defender of rights, which is the independent structures in charge of the issue of whistleblowers in particular. It is necessary to create an inspection of whistleblowers directly attached to the defender of rights, whose mission would be to take charge of the alert and to accompany the one who launched it with the help of specialized thematic commissions. This inspection must be given substantial means, which is not the case today, and it must have a power of injunction for the communication of documents useful for the treatment of the alert. Those are the few words I want to share you about my work as a member of the French Parliament on whistleblowers. There is still much to be done, and as I often say, we will never give up. Thank you for listening, and I wish you all a good day and a good conference.